I want to thank you for attending. If you can all please stand for the Pledge of Allegiance and remain standing and just, oh, Lord, my mind is a blank.
Take a breath.
I know. To honor all those serving across the world. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. They pummeled me in therapy today. Good evening, everyone. I want to thank you for attending the Village of Woodbury Planning Board meeting of December 6, 2017. Introduce board members and our consultants. To my right, we have Robert Anzalone, Sandra Capiglione to my left, Richard Cottaggio to far left, Gail Nogel, our secretary. We have Dennis Lindsay, our engineer, Jonathan, our planner. We have Rick Golden, our attorney, and I'm Maria Hunter, your chairperson. Board members, have you had a chance to review the minutes from November 18th? And if so, do I have the 15th? I'm going home, that's it. Meeting adjourned. No, only kidding. Minutes from November 15th. Do I have a motion?
I make that motion.
I'll second.
Any discussion?
No.
All in favor?
Aye.
Aye. That's 4 yes. First item on the agenda is Melody Lane property. A public hearing for proposed amended site plan to include a freestanding sign, Mercedes-Benz. Said property is located on Melody Lane, is known on the Village of Woodbury tax maps as Section 225, Block 1, Lot 36. Okay, and for the record, on November 16th, we received for GML from Orange County DPW, and today, dated from the Orange County Department of Planning, we received local determination. And what else? Reports. All right, Mr. Litko.
Good evening. George Lithgow from Jacobus Guvitz for the applicant. With me is Connor McCormick from Mazer Engineering, or Mazer Consulting, who has been working on the sign design and location.
The microphone on?
I believe so.
Okay.
So what we're seeking to do is amend the site plan. We would like to add a freestanding sign to the south side of the entrance of the Mercedes project. We had originally hoped to be able to put a sign closer to Larkin Drive. We encountered difficulty with Orange and Rockland at the proposed location, so at this point we're proposing to put it on the property adjacent, immediately adjacent to the entrance. I think probably the simplest thing, if there are members of the public, is for Connor just to show you the location. We did receive some photographs recently. I know you don't usually take submissions at the hearing, but this is a new kind of, it's a new model of Mercedes sign. It's a new branding. It's black Mercedes, and it was very difficult to get illustrations of the sign as installed, but that will show you the appearance, and Connor can explain the interior lighting of the sign.
Thank you.
Thank you. Good evening. I'm Connor McCormick with Mazer Consulting. It's a pretty simple plan. The first page, we were just showing the setback from the current edge of pavement.
Connor, can you do me a favor, please? Can you please take that microphone with you so we can, because you're being recorded for TV.
Sure.
Thank you.
Can you hear me now?
Yes, I can.
Okay. So right now we're showing a setback from the edge of pavement 15.4 feet. It's on the left-hand turn. The biggest concerns we got as far as comments from the engineer, were illumination of the sign and sight distance. As far as illumination goes, it is a self-lit sign. As you could see from the photos, there's 2 areas that are lit. It's the actual symbol itself, the white Mercedes sign, as well as the sides. They're baffled, so there will be no direct light. We are still in talks with the sign manufacturer's engineer as far as the exact specs on the illumination. So that is something we're still waiting for. Talked to them yesterday, and they were still trying to get that to me. As far as sight distance, we agree with the engineers.
Connor, can I just ask you a question as far as the lighting goes? On
Yes.
the pictures that you gave us, it looks like there's also ground lighting.
Yes.
Are you having that as well?
I should have mentioned that. That there will be no ground lighting. That was a
Okay.
specific case. There's only a certain. There's not a whole lot of these built right now, so that was the closest picture I can do. That particular sign, since we're mentioning that, is also not the exact height of the one we're proposing, but the lighting is the same. As far as sight distance, the direction of biggest concern is going to be from the south, the development here. Because there is a roundabout to the south, which I'll show you by flipping over to the. Thank you. The roundabout here. Left turn won't be of concern, which we agree with the engineer. When we spoke to our traffic department as far as the required sight distance, we were getting a sight distance of 155 feet. We spoke to Dennis Lindsay on the phone yesterday and today, and we were talking about ways we could provide that and possibly pulling the sign farther back than what we have right now, currently 15.4. That is, I mean, that's pretty much it. It's the freestanding sign, self-illuminated, with the only remaining concern being sight distance.
And the height again is
I believe it is.
it the 7?
It's on that first page.
13.
Yep.
13? Okay.
13 feet, 1.5 inches, it looks like.
Okay, there we go. That's the one that's circled. That's the one I couldn't read. My eyesight is going. All right. As our normal and customary, we go to our consultants. Is there anything else, Connor?
That's all I have for you.
Okay. You good, Mr. Litko? Dennis?
There's not much. I think Connor covered it. We asked about the illumination, and it's internally lit. As far as the sight distance, I think although you can reach the minimum stopping sight distance, perhaps with the 155, that's for a car that's maneuvering on Melody Lane to stop if a car is coming out. For a safe exit from that corner there, they should have a little bit more, and it's coming around a blind curve. The sign provides no opportunity whatsoever to see past it. So with a slight adjustment that we talked about, they can move the sign back, and the sign will not be an obstruction. There are going to be some shrubs and some trees that are associated with the bioretention area there. Right now, as I understand it, they're manageable. You can see a car coming around there because it's not so full. If that grows in and becomes dense, it may be hard to see, so that should be maintained properly for a reasonable sight distance. If they move this sign back, I think we'll have an ample opportunity to provide fair sight distance for drivers in that area.
Thank you. Jonathan?
We just have a few comments. We checked for the height limit. 25 feet's permitted, and it's almost half that, 13 feet, 1.5 inches. 200 square feet's permitted. It's only 50, a little over 50 square feet. So it's within the proper size, proper height, proper width. The minimum distance from pavement is 12 feet. So If it's at 15.4 and they move a little further back, that's fine. And we had noted that the site distance to the south was only 110 feet, but it sounds like they're working on that. The county DPW review had no comments, and we don't believe that you need to do any other work on seeker other than confirming that this is captured within the extent of the original seeker approval.
Thank you. Rick?
As you know, that we proposed a draft second amended resolution. There is one aspect that needs to be modified, and that is because today we received the GML 239 report from the county. So I can read to you, when you get to the resolution, how I would propose to modify the language on page 4 of the resolution.
Okay.
And I have no other comments.
Board members, since it's a public hearing, do you want to hear from the public before we discuss this?
Yes.
Okay. Could you just do me one favor? Could you just hang up one of these colored paper, Connor, just so the public can see it?
Absolutely.
Just so they have an idea what we're talking about. Thank you. Okay, this is a public hearing for the Melody Lane property. It was posted in the record on December 1st. Notice is hereby given that the Village of Woodbury Planning Board will hold a public hearing at 7:30 PM on Wednesday, December 6, 2017, at Woodbury Town Hall, 511 Route 32, Highland Mills, New York, in the matter of the application of Melody Lane Property LLC for proposed amended site plan to include freestanding sign, in parentheses, Mercedes-Benz. Said property is located on Melody Lane and is known on the Village of Woodbury tax maps as Section 225, Block 1, Lot 36. Okay. Anyone in the second row would like to come up and make any comments on this sign? Anyone in the third row? Anyone else anyone in the building? Third row, fourth row? Okay, I had to count back another row there. Anyone in the room who'd like any public comment? Board members, with no one coming forward, do you have a motion to close the public hearing?
I make that motion.
Do I have a second?
I'll second.
All in favor?
Aye.
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 Okay, Rich, thoughts, concerns, questions?
I'm good.
Sandy?
I just wanted to know, as far as moving it back, how much farther are you talking about?
When we looked at it, it looked like you could get to the center lane of the road on the curve by moving it to 23 feet as opposed to, we had been looking at 16, was it?
16, 16 was the first draft we looked at that was getting that 155. But there was concern about that curve.
So
that
it's
blind
about
curve.
7 feet further back.
Yeah.
7? Okay. That's it.
Okay. Robert,
I'm good.
you good? All right. Being that this is all new technology and signage for Mercedes-Benz, I'm impressed with the sign. Being in the area where it's located, I think it'll work well. Once we figure out the setback with the signage, for sight distance, I think we'll be okay. Board members, any other thoughts, concerns?
No.
Pleasure in reading the draft of a resolution?
Yes.
Good, Rich? All right. Mine is dated last revised December 4th, 2017. I have the correct one, Rick?
That's correct.
Okay. Draft a second amended resolution of approval of site plan, special permit, freshwater wetland permit, and architectural review board for Melody Lane Property LLC, in parentheses, AKA Mercedes-Benz of Orange County. So I would presume on page 3, do we need to do anything about GML referral there, Rick? Or is it on page 4? Page 4?
On
Oh.
page 4, and what I propose is that the second and third sentences be deleted.
Okay, that's the one that's,
That's the one that now reads, "No response has been received from the
Okay.
Department of Planning, 30 days has passed. Therefore, the planning board has the jurisdiction."
okay.
has no jurisdiction to take the application.
All right.
So, in its place, what I suggest that it says is that the Department of Planning issued its report dated November 29th, 2017, concluding that it is a local determination, finding no evidence that significant intermunicipal or countywide impacts would result from the application's approval. I'll read that again.
Okay.
The Department of Planning issued its report dated November 29th, 2017, concluding that it is a local determination. Its initial caps on local indetermination.
Okay.
Comma, finding no evidence that significant intermunicipal or countywide impacts would result from the application's approval. And then the last sentence in that paragraph would remain the same.
Board members, are you okay with that additional language and the deletion of the other sentence?
Yes.
Okay. Representative, you're okay with that language? Okay. All right, so we have a resolution of approval, which begins on page 6, under specific conditions. Wow, there's only 3. 1, all applicable conditions attached to the site plan, special permit, architectural review board, and freshwater wetland permit approval from 2015 to the present Melody Lane Property LLC, also referred to in the same Mercedes-Benz of Orange County, and any subsequent amendments thereto are hereby incorporated into this resolution and are to remain in full force and effect, and this approval is subject to and conditioned upon satisfaction of those conditions as if they were set forth at length herein. And I did not forget about reaffirming secret, Jonathan. I'll do it after I read this, before we vote. Number 2, if illumination is intended, the applicant shall provide proof of conformance with section 310-330 in parens, subparagraphs D, number 3, of the village code to the satisfaction of the building inspector. 3, prior to the signing of the plans by the chairperson, the applicant shall comply with the memorandum of the village engineer dated December 1st, 2017, to the satisfaction of the village engineer. Anyone have any comments, thoughts, or concerns of what I just read with specific conditions? Go ahead, Dennis.
Okay. For that last one, I'm going to suggest that at the end where it says, "To the satisfaction of the village engineer," which shall show a setback of 23 feet to the leading edge of the sign, rather than the 15.4 feet shown on the plan identified herein.
You want to read that one more time, please?
I will try. Which shall
Board
show
members-
a setback of 23 feet to the leading edge of the sign, rather than the 15.4 feet shown on the plan identified herein.
54 point what?
15.4, rather than the 15.4 feet. So the new distance is 23 feet.
Okay.
And I also have one more, adding a new item 4.
Just give me a second. Board members, you're okay with that additional language?
Yes.
And
Mr.
new item,
Lithgow? You're okay with that language?
Yes.
Okay.
new item 4 would say that plants in the bioretention area are to be maintained to avoid impacts to site distance.
Can you read that again?
Plants in the bioretention area are to be maintained to avoid impacts to the site distance.
Board members, you're okay with that? Mm-hmm. Mr. Lithgow? Yes. Okay. All right, before we approve the resolution, I would offer a motion that we reaffirm the SECR for this project.
We didn't do that on November 1?
I don't think so.
Okay.
No, because,
All
hold
right.
on,
My notes had said we did, but
we did?
it's all right. We
I
can-
didn't write it on my folder here.
Why don't we just do it tonight? That way it's
We'll
nice
do it on,
and
to-
clear.
okay. So, my motion is to reaffirm secra on this application. Do I have a second?
I'll second.
Any discussion? All in favor?
Aye.
All right. Do I have a motion to accept this resolution of approval with the changes discussed here tonight?
I'll make the motion.
Do I have a second? I'll second. Any discussion? All in favor?
Aye.
Have a good night.
Thank you.
You're
Thank you.
welcome. Happy holidays, thank you. We'll give a set to, we'll give a set to Gail, and she can give it to Maria. If she wants, she can have my set. You want your pictures, you want me to give them to Maria? Well, we have to put one in the file. I'll make sure she gets one. Okay, next item on the agenda is Woodbury Diner. Public hearing for an amended site plan and ARB review of exterior renovations to the existing Woodbury Diner located at 220 Route 32 in Central Valley. Said property is shown in the Village of Woodbury tax maps as Section 229, Block 1, Lot 27. And for the record, here's my papers. On November 16th, we received the revised ARB application. On November 16th, we received the Orange County DPW GML. And then tonight, or today, we received from the Orange County Department of Planning, local determination. Rick, you saw what the County Department of Planning wrote in their little letter there about, aside from comprehensive plan changes and adoption, only the following must be referred for individual developments.
True, but
We
what's a
still
little
do it-
surprising from that is that this was more than just an ARB.
Yeah. Okay,
But they responded and they gave it a local determination, so that's what we're going with.
okay. With that being said, Mr. Spisto, you have a plan up there, beautiful. Give us a brief overview of what you plan on doing.
Good evening. For the owner, my name is Richard Spisto of Design Group right here in town. I'm sure all of us here in the room have had a breakfast, a cup of coffee on a cold day, business meeting, and many other functions at the old Bright Star Diner. It's been here many, actually decades. And when I was approached by the new owners to redesign the entire building for a more updated look and redo the whole interior also, I was thrilled to hear it. My business is right across the street, and breakfast is good there. So they intend on putting forward a quality product, including fresh bakery on site and so on. So it's good to hear that also. My approach in designing was to keep in the tradition and architecture and some of the typical materials you find here in the town of Woodbury and actually throughout Orange County. So I started with a strong base of stone, grounding the building to its site. The main surface and facade of the building itself is stucco, tan, accent points and in stucco also. New awnings, new lighting, and lighting is designed to pretty much light the new ramps, steps, entryways, and so on at the perimeter of the building itself. So all in all, keeping with the tradition here, we have columns and gables and so on, and it'd be a nice change for the town itself. Hope you like it. Any questions?
Well, as usual and customary, I'm going to go on down the road to Dennis and go over his report, if you don't mind.
Okay?
And you did bring samples for the public tonight?
Yes.
Okay.
For who?
For the public to see?
Oh, yeah.
Okay,
The sample board?
yep.
Where would you like it?
It's the same sample that you showed us, right?
Yeah, except I've got everything written out for you this time.
Okay, perfect.
You could tell this one.
Okay, for right now, all right, I'll hold this up here if anyone wants to see. Okay. Dennis?
Yeah, there's not much on this. For the ARB, the materials, you just mentioned that. You should take a look at the materials, make sure that everything you have is consistent, so that Gary knows what action you're taking, and that it's clear on the plans and on the materials, on the materials list. The applicant did submit a new ARB application materials list. As far as signage, you talked about the signage at the last meeting. The applicant said that they would stay within the existing box and it would have internal lighting. They didn't have a sign yet, but I think they were going to give you a range of colors that were proposed for the sign so you could understand what that was going to be. As far as the site plan, we didn't see the site plan before. It was a very simple site plan, but after council reviewed this, it was determined that even though there's small changes, the changes made the application rise to the level of an amended site plan, albeit a minor amendment. The applicant, we asked to have something in the file so that the action of the board would be clear to the building department. They have provided an adequate map, in my opinion. It's a Google Earth or some aerial image. Actually, it is a Google Earth map, and it does say the date that it was taken in 2017. It shows the improvements that are proposed. You have the authority to waive the requirements in your code in terms of a formal site plan. The site plan requirements are rigorous, and they would be rather expensive and unnecessary for the changes that this applicant is proposing. So our recommendation is that you would accept this plan as a reasonable, considering the information that you need. And that's all I have, except for the lighting, the hours of the lighting. It's going to be the same as the business?
I would say so, yes.
Okay. All right. That's all I have.
Thank you. Jonathan?
We don't have any further comments on this one.
Thank you. Rick?
We had provided thank you. We had provided a draft resolution of approval. There needs to be a few changes, two of which I'll talk about now, and others I need the board's determination whether they want to change. Excuse me. The first is on the second page, where it is listing,
Is this the one dated November 20th?
yes, it is.
Okay.
Number 3 now starts with plans prepared by, and I propose that it start with a Google Earth depiction and plans prepared by the design group. And let me ask Dennis, if number 2, where it says the ARB application last revised November 16th, is that the last one, or do we have one after that? And while Dennis is looking at that.
November 16th, yes, that's
Okay.
the one I have.
The GML 239 referral, we can keep the language as it is, just put it in regular typeface rather than the bold italic, and fill in the date being November 29th, 2017. And there were 2 issues, and I'll leave to the board and Dennis's input on this as to whether you want other specific conditions, one of which would be that there be compliance with Dennis's memo prior to the signing of the plans, and that would be it. I apologize, there was just one other.
Okay, thank you. Board members? Yes, we'll probably, you'll keep that, and that'll go into the file, but that can go to Gail. But I just want, if anyone from the public, in case they want to see any of this, okay? Gail, if you can take that
November
picture
30th,
that
right?
Rich has, we'll give it to Gary for the, Maria for the file. Board members, you have any thoughts or concerns before I open this up, since it's a public hearing?
I just want to ask, is the roof line identical to what it is right now? The roof
Oh,
line?
I'm sorry.
Is the roof identical, the whole line of the roof identical in your diagram as it is now?
In height?
In height, in width? I mean, off to the left looks a little bit different, I mean, unless it's just that angle.
Left and right are pretty much the same. There's an overhang with a gambrel-type roof on it. That's about the same. The front obviously is
Microphone,
different
please.
with-
Microphone.
The front obviously is with gable roofs and so on. The top of the largest gable, right up here, is about 6 foot above the existing roof line now. But the
So yes.
average of this roof is the same as the building that's there.
Okay, thank you.
Anything else?
No, that's it.
Sandy, Rich? Okay.
Just on the sign, do you have a color in mind for the sign, or still no?
I met with them this morning, and pretty much I think they're just gonna be putting large letters, they're backlit, will say Woodbury Diner. The sign, we were talking last meeting that keeping it with the building colors, try to reflect that in the sign.
So
I
getting rid of the
imagine-
yellow.
I imagine the letters will be something like a dark red or something like that, or something where light comes through. The background will be a tan or browns.
Okay.
Might be 2 colors, maybe 3 max.
3 colors is the max for the code.
Right.
Okay.
That's the way it looks.
Yeah, that's the current photo if you want to look at it. Rich, any thoughts, concerns? Before I go to the public? All right, I'm just going to ask you to have a step to the side in case anyone wants to come up and speak. Being that this is a public hearing, notice is hereby given that the Village of Woodbury Planning Board will hold a public hearing at 7:30 PM on Wednesday, December 6, 2017, at Woodbury Town Hall, 511 Route 32, Highland Mills, New York, in the matter of the application of Richard Spisto for an amended site plan and ARB review of exterior renovations to the existing Woodbury Diner located at 220 Route 32 in Central Valley. Said property is known in the Village of Woodbury tax maps as Section 229, Block 1, Lot 27. With that being said, does anyone in the second row want to speak on this application? Anyone from the third row would like to speak on this application? Anyone from the fourth row? Anyone at all in this building who would like to speak on this application? With no one coming forward, I will offer a motion to close the public hearing. Do I have a second?
A second.
Any discussion? All in favor?
Aye.
Aye. And oh, I should have put this, this is the color scheme, sorry about that. Better late than never, I could always rescind, all right? All right. You can hold on to that. Shame on me. Thank you. I'll pass this down to Gail in a moment. Okay, board members, what is your pleasure at this time? Robert?
Read the resolution.
Sandy, any thoughts, concerns? Rich? Okay. All right. We have a draft resolution of approval dated November 20th. Amended site plan and architecture review board for 220 Route 32, R32 Realty Corp., AKA Woodbury Diner, AKA Central Valley Diner. On page 2, as noted by Rick, we put in there the Department of Planning dated 11/29/17, so that'll be part of the record.
We also changed on the same
Oh, yes.
page, the a Google Earth depiction and
Yes.
in paragraph number 3 under
Paragraph
plans.
number 3 at the top of page 2. Board members, you're okay with those changes?
Yes.
On page 3, we have a resolution of approval, specific conditions. No building permit shall be issued authorizing construction of a structure or internal building development inconsistent with the architectural rendering submitted to and approved by the Architectural Review Board as part of this approval, nor shall any certificate of occupancy be issued for any structures constructed except in conformance with such renderings. Any deviation from such renderings will require further planning board and/or building inspector review as the zoning code requires. Number 2, all light levels must be limited to 0.1 foot candles at the property line, so no off-site glare will result. The fixtures shall meet IDA, LEED, or Green Globe's criteria for nighttime friendly or dark sky lighting. Any wall pack fixtures shall include non-glare shields. The hours of lighting shall be the same as the hours of operations as noted on the plans. Dennis, I believe you have a number 3?
Yeah.
Or Rick? I'm
Yes.
sorry. This is
Number-
Rick's turn, I
Number
guess.
3 would be, there must be compliance with village engineer H2M memorandum dated November 30th, 2017, prior to the signing of the plans.
Mrs. Spisto, you're okay with that?
What is that?
Did you get a copy of the memo?
From you, Dennis? Yes, I did. I got it.
Okay, so you're good.
Okay,
All right.
all right. I got it.
Board members, you're okay with number 3?
Yes.
Is there a number 4, or is that it? That's it. Okay. Board members, what's your pleasure with this?
Approve the resolution.
Approve the, all right, do I have a motion to approve the resolution?
I'll make that motion.
I second it.
Any discussion? All in favor?
Aye.
Aye. All right,
Thank you.
have a good evening. I don't want to get home, do I? Have a good night,
Good
sir.
night.
Sorry about that. Next item on the agenda is Woodview Heights, discuss extension request for preliminary subdivision approval. Said property is located on Hill Avenue in Highland Mills and is known on the Village of Woodbury tax maps as Section 204, Block 1, Lot 34.2.
Good evening.
Just give me 1 second, please. I just want to make sure I don't have to acknowledge anything. Let me just check my notes real quick. All right. All right, you're good to go.
Good evening. My name is Jay Myro. I'm an attorney with Bluestein, Shapiro, Rich, and Barone. We're the attorney for the applicants.
And I'm Craig Dominic on behalf of AFR Engineering Group in Monroe, civil engineers.
So the last time we were here, we agreed, we were given an extension of our preliminary approval, and upon the agreement that we would submit a report responding to Mr. Lindsay's memo in May. We submitted a report. We've received Mr. Lindsay's memo in reply, and I don't know, I'm assuming, oh, we have Stu Turner's memorandum also. So basically, what we did was to take a look at what the current zoning would require, and the plan essentially at this point, we've determined that there would be a loss of at least one lot due to stormwater regulations, which were obviously come into being after our initial approval was given in 1995. That's probably going to cost us one lot. The main other regulation that is going to would cause us to lose density here is the newer slope ordinance, which is going to cause us to lose, would cause us to lose some lots. So I don't know, Rick, do you want me to, at this point? All right.
Yes, please, thank
I
you.
can jump in if it makes sense. As everyone knows, this application has been around for a very long time. There was a very long period of time when they couldn't proceed because of circumstances beyond their control with respect to sewer availability. But for some time now, many years now, there has been availability. The applicant has demonstrated over those years clearly no intent to stop working on this application and to abandon it. You have a valid preliminary approval for the subdivision. and we would be working toward a final. I think there's been some confusion over the conflation of two issues, so I want to make sure that they're clarified here for everybody's benefit. One is that must this application comply with present zoning? It was approved many, many years ago, and there have been changes in the zoning code, most notably net lot area being applied to this application, and potentially some others. So that question of whether or not the present zoning applies to that approval that was received years ago, the answer is clearly yes. There was some confusion in a memorandum, I think, from the applicant about vested rights, but vested rights don't apply in this circumstance for many reasons. I won't bother to draw this out unnecessarily. But clearly, and I believe that the applicant's attorney agrees, that they are subject to the present zoning of the code. And they, I believe, and council will weigh in, but I believe that they would like an further extension of time to address that issue of noncompliance and hopefully get a variance from the ZBA. My advice to the board is that you ought to grant a reasonable period of time for them to proceed to go before the ZBA to see if they can get a variance from those provisions that now apply to their application, which didn't previously when it was granted. I think, obviously, you don't want to extend it without a limit so that we could again go many, many years without resolving this. But I think that if you put a reasonable date on it, I think probably March is a reasonable date that would allow the applicant to make an application to the ZBA to go through their process, which takes some time, and they also have the ability to have 60 days to make a decision. So I think March is probably a reasonable time for you to give the applicant to proceed in an expeditious manner before the ZBA. So that's one issue. The other issue is there were questions raised earlier by this board saying this approval is so old, can we simply say that it's too old and knock it down and make them start over again? The simple answer to that narrow query is no, you can't. Simply because it's old is not a basis for you to deny the prior preliminary. There are certain rights that the applicant has to continuing on with their application. There are some exceptions, only one of which I think might apply, and I'm not sure that it does, but the only one that might apply is if, since that approval, there has been significant material changes to the area such that the approval that was given really doesn't have any relevance anymore. So it's a fairly high bar. But for instance, let's say it was approved, and this is just a hypothetical, it has nothing to do with this application. It was approved at a time when everything was pastures and there's no problems with a lot of traffic, and they waited 15 years, and now all of a sudden you have a ton of traffic, and you would not have granted the same sort of traffic access and circulation, et cetera, if those significant material changes in the surroundings were back when it was originally approved. And I'm not sure that there is any such significant and material changes to the surrounding area. But if you are inclined to consider that as a basis to revoke it, again, this is very separate from whether or not he has to comply with zoning, but if you want to revoke it for not their abandonment, because they clearly haven't abandoned it, but because of the changed circumstances over all these years, you would be required to grant the applicant a hearing so that the applicant can present evidence to you, presumably saying that there were not significant material changes to the degree that you ought to revoke their preliminary approval. So I think that the threshold question is, are you considering that? And you may want to hear from Dennis, who's long in the tooth here, with respect to changes that have developed over time since this was originally approved, and potentially other members on the board. And if there's a possibility that you are considering this, then you should set down a hearing before taking that action, and then you would have if you're going to go down that route, whether you should do that before they go for an area variance for what they're requesting on the new zoning. If you're not considering the revocation of their prior approval, then you don't need to do anything, and they can simply go to the ZBA and try to get their area variance as needed. That's as simple as I can make it.
I have no problem with Rick's synopsis.
Thank you. Where do I go?
Oh, just get more consultants there.
I know. All right, so go on.
Jonathan wants to talk.
Go our normal route, go on normal
Yeah.
route? Go ahead, Jonathan.
Sort of, instead of left to right, it's right to left. I guess at this point, I'd like to add that the purpose, I think, that the applicant had when they did this November 2nd discussion plan was try to do an analysis for you of if they were required to meet the modern, today's zoning code and subdivision code. How far out of compliance was the preliminary plan from 22 years ago? And, you know, how much of a reduction in lots would there be? And I just wanted to point out that it looks like, from the attorney's opinion, that either they're going to go to the ZBA and seek an area variance, which they will get or not get, or the planning board has the ability to consider revoking the preliminary approval, in which case they would have to meet the modern standards. So there's two ways the applicant could end up having to meet the modern standards. And I would just want to point out that I had some issues with the way the calculations were made in their November 2nd discussion plan and in the report that they sent along with it. Some of the numbers didn't add up, and it's not our responsibility to help them get the right variances. You know, it's not our responsibility to help the applicant seek the proper variances or the correct numbers from the Zoning Board of Appeals, but I just wanted to sort of point out to that in a helpful way that if they would review our analysis and make sure that they ask for the proper relief for each of these lots, because then if they came back with variances that didn't add up, we'd have problems. But the net lot area definition that Woodbury has adopted is tricky, and yet one has to be very methodical to meet the standards.
Thank you. Dennis?
All right, I share some of Jonathan's concerns about the calculations, so that they would have to be done by the applicant. Two other things that I'll refer to. One is that we do have other regulatory agencies that have adopted new regulations and that require compliance, and one is we're an MS4 community under stormwater. They will have to comply with the requirements for both retention and for water quality on site, and that most likely will require the reservation of some property, which will impact lots for them. But that's a requirement that'll have to be taken care of. The other thing is on the area conditions. This was first applied for in 1989, and it was approved in 1995. There have been changes to Woodbury clearly since 1995. You've had expansions of Woodbury Common, you've had development of Woodbury Center, you've had Harriman Business Park for your large developments, and as far as residential, Highland Lake Estates came in after that, or right around that same time, Country Crossing. You've had now WP3, Woodbury Junction, Strawtown Farms came in and was expanded, and Brigadoon, I don't know if I mentioned that one. But anyway, and Country Crossing, there were a number of developments adding hundreds of new homes. However, in this particular case, those probably gravitate down to 32 and some of the other county roads where you would see some heavier traffic. But in terms of this application, the most significant impact of this application is going to be on Hill Avenue and is going to be down in the local area right around the development. Those were concerns expressed at that time during the hearings on this application. There were residents from the area that came and had expressed concerns regarding traffic in the immediately adjacent area. That was considered by the board. The board made modifications to the plan that they deemed appropriate and eventually gave this preliminary approval. So anyway, that's a little history and what I recall in terms of the application and the changes in the area. Unless you have any other questions, that's all I have.
Thank you. Robert,
Okay.
we'll start with you.
While there's been changes, I don't think they're to the level of what you see on Route 32. I don't think I'm in favor of revoking the application. I think they should go forward with the ZBA. That's my feelings on that.
Okay. Sandy?
I would not be in favor of just pushing it to the ZBA. I feel, personally, I feel like we're going to be looking at a plan that's been piecemeal together over time, and I'm just not, I'm not comfortable with doing that. So I guess I don't want to give any more extensions. I've voted no on the extensions. And if it means that we have to have a hearing, I would rather have a hearing.
Okay. Rich?
Okay, I need some clarification. When you said a hearing, Sandy, what is she referring to? I understand the first part of her comment, but the hearing, what are we talking about here?
Rick?
What the law recognizes is that when you receive a preliminary subdivision approval, it's much more than the name sounds, as you know. That entitles the applicant with a preliminary subdivision approval to a right to a final subdivision approval, provided that the final subdivision is in substantial compliance with the preliminary. So they have a right to do that. And so the law says you can't just say, because of a passage in time, we're going to revoke it because too much time has happened between the preliminary and the final. Unless they've abandoned it, which clearly they have not. They've come in routinely and asked over the years for extensions. They have not abandoned their desire to develop this parcel as a subdivision in accordance with the preliminary approval. There is another avenue in which it could be revoked if, as I said before, that based upon the passage of time, a significant period of time, a material change in relevant circumstances requiring re-examination of the previously approved plat. So there has to be significant changes in the surrounding area that would cause you pause to say, there's no way that we would have given an approval if the conditions were like they were. So there has to be this very close nexus between the changed circumstances and what you want to change and don't like about the previously approved subdivision plat. It can't be just that there's a lot of time and that you don't like the subdivision plat. If you're going to consider that, the law says that you are taking away rights that they have in that preliminary approval, and therefore you have to give them an opportunity to present to you evidence that says that there hasn't been such a significant material change in the circumstances. So that requires essentially a hearing, an opportunity to be heard. It's not necessarily a hearing like you see on TV or something where the witnesses would come forward and there would be sworn testimony, but you have to give the applicant an opportunity to be heard as to why there has not been that kind of significant material changes in the circumstances, so that they can present that to you and you can make an informed decision.
Okay, and again, if the applicant is leaning towards the reduction in lots, that's what I heard, we need to go to the ZBA. And I understand why, for the bulk and the changes.
Yes, one of the changes was that it's going to be subject to a net lot calculation of the area. It wasn't back then, it is now, so they would have to comply with that now. And regardless of whether or not there's been any changes to the area as a result since that time that they were approved. So they would have a right to go to the ZBA to ask for that variance. They may get it, it may be denied. If it's denied, then they have to comply with the current code as it is, and they may lose lots. They may lose lots even if they get a variance, because the ZBA may not give them all they want. The ZBA may condition some of the variance that they give to them, such that they have to do certain things. And I also want to point out that the only things that they can ask the ZBA to do is varying the zoning code. So for instance, Dennis mentioned before that the village is now an MS4 community, which it was not when this approval was obtained. So they would have to comply with any kind of MS4 requirements and regulations and possibly changes in the plan. They could not get a variance from that from the ZBA.
Okay, so if they go to the ZBA and they get approval, does that mean they have to get approval?
They would get a variance from.
A variance?
Right.
Does he have to come back with a new revised site plan?
I'm assuming some things, but I would say yes, because the MS4 requirements that have to revise their plans, if they revise their plans in any way, they have to come back before you, except if it's a de minimis field change, which this would not be.
And I'm assuming that would also include maybe sewer, since it wasn't available the last 20 years?
Dennis, I'll let you
I
weigh
think
in.
the sewer was shown, there was a dry sewer shown on the plans, so I don't know that there's a need to change. So that wouldn't change, but there clearly would be, it would be a non-de minimis change. It would be a significant change, most likely causing the loss of a lot to comply with the MS4 regulations. Not guaranteed, because they could do things below grade, but we would have to review and approve that, but it would be a significant change.
Okay, and this site drawing that he has here, you haven't gone through it yet. Is this the original, or is this is this a?
No, that's a representation of the original.
Of the original.
What was added here is this table, which will show basically the nonconformity to today's ordinance.
Okay.
Well, it shows somewhat of the nonconformity. There's some calculations that need to be adjusted on there, and then they'll have the final nonconformity, which they can go to the ZBA with.
Okay, so again, I'm just thinking ahead of the possibilities here. If he goes ahead to ZBA and he gets approval, and he comes back with a revised subdivision, site plan, does that require a change to the GML that was approved in 1994?
Yes.
And two, it does?
Yes.
Okay, and two, do we need a public hearing again because of the change?
That would depend upon the change. What the law requires that when you're going from preliminary to final, if in fact it's in substantial agreement, if the final that they ask for an approval is substantial agreement with the preliminary, then you're not allowed to ask for a hearing on the final. But if it is not in substantial agreement, there have been changes made that you conclude is not in substantial agreement with the preliminary as approved, then you have a discretion of having a public hearing on the final subdivision approval.
Okay. All right, so, and if I don't want to wind up in a tie here.
No, it's okay. I'm
Well,
listening.
I'm just saying, if it winds up in a tie, what happens?
I'd
Well,
ask-
You can-
I'd be
you can-
asking the board to adjourn to wait for the other member to come in, so.
Yeah,
and you can do that, but they're not mutually exclusive. All right? So you can allow the applicant to proceed to the variance
mean to the ZBA?
to the ZBA
Right.
for a variance. And then you can still make a determination if a majority of the board believes that they want to revoke this because of the substantial and material changes in the circumstances. Then you would have them also appear here and allow them to present evidence. But what the applicant is asking for is if there is not a majority for them to simply go to the ZBA without the possibility of this revocation, then they would ask that this be adjourned until you have a full complement of board members. And you have done that in other circumstances, so I think that would be a reasonable request.
Can I just say, I'm,
Yeah.
is it okay?
Yeah.
Okay.
You're-
I'd like to just point out two things. Obviously, I'm urging the board to please not revoke us, let us, and there's two things I'd ask the board to consider. One is that if you're considering a substantial change over the years, the one thing that is not, well, I don't believe it's changed, but the one thing has not changed is the zoning classification for this parcel. It's still a residential zone. It was a residential zone. Even if you revoke, ultimately, if it's developed, it's going to be developed as a residential development. So to the extent that that change hasn't been no change to that extent, I think that's significantly relevant. The other point I'd like to make is that what we are trying to do here is to bring the development into full compliance with current zoning. That would be the end result. And part of that is us exercising our right to go to the ZBA if there is a particular bulk requirement or an area variance we think we're entitled to. If we go there, get it, we come back, the consequence of that variance means that for this particular project, we are in full compliance with the zoning. So we're going to have to go make our case to the ZBA. Part of their analysis, and there will be a public hearing, is going to be whether we have a substantial impact on the neighborhood, whether there's a substantial impact on the environment, whether it's a substantial, whether there's another feasible way, and obviously whether it's self-created. But I think that to get over this high bar that Rick described to you, to revoke us, I think is way too high under the facts and circumstances that I've heard. And when you factor that in consideration, that we're trying to bring it into compliance, I'd ask the board to let us let us proceed without that hanging over our head.
Okay, Rich, anything else?
No, I'm just, based upon his comment, going towards compliance, and based upon Rick's comments, that we still have the right, the planning board, to revoke at the end, even with the ZBA, correct? After the ZBA's decision.
You do. What the applicant
Yeah.
is asking is that unless the vote is going to be in favor of no revocation,
Right.
he would like to adjourn the matter so that there's 5 members here to make a determination on there, because he doesn't necessarily want to go through the process of an expense and delay before the ZBA if at the end of the day this board is going to throw everything out, which is not unreasonable. I think that's the applicant's position.
Okay. No, I'd be in favor. I'd like to hear what the ZBA has to say.
Dennis, just for my clarification, back in 1989 to 1995, it was residential. What was the code back then? R1A?
I
Is
think
that
it's the
changed?
same, the only thing they had there, they had lots served by public water and sewer and lots not served by public water and sewer. I think those were both as of 9/25/90. It was a residential zone. Whether they changed it, I think they were both, I'm not sure, I'd have to look at it. I think it was 30. One was 30, well, yeah, but it was still the same zone. They had a different lot area requirement depending upon whether you had water and sewer on site or whether you were getting central water and sewer. but it was still under one classification.
That's
And
correct.
I think it was the R1A, but I'm not sure if that was a designation at the time.
Alright.
I'll check that for you.
All right, I definitely need to have that because, oh, God.
They were both resident, it's
I-
correct that they were both residential zones.
Right, it was residential, but I know the codes have significantly changing with the requirements and everything.
I don't really believe the name of the zone back then and the name today is relevant, but the standard back then was 1 acre, 40,000 square feet, unless you had central water and sewer, then it was reduced to 30. Now, it's just 40,000, 1 acre.
Right.
All the time. That's the difference.
That's the difference.
And I wouldn't stress on what it was called now, what it was called then. It's really just the standards.
It's the standards.
That's
Right.
important.
To me, that's the way the code was. To me, that is significant. But I am hearing what I've heard from both attorneys and my consultants, and, yeah, I'm gonna say, I'm gonna have to send this to the ZBA. Because the substantial change, it is the standards from the 30,000 to 40,000 within the, everything. And the zoning board is gonna have to make a determination once we send this to them. And if the zoning board feels that we're not in non-compliance, you have the right to come back with a revised plan.
Yeah.
And then we can do final and preliminary all together, as we've done in the past. So I'm just,
That's what
Depending
we're,
what-
that's what we're asking for.
that's all you're asking for.
We realize we're gonna have to comply at the end of the day. Either I
Right.
get the variance
One
or
way
I
or the other.
don't. If we don't get it, we may have substantial loss of lots, but we're gonna have to we would just like the ability to get that answer and be able to come
Right.
back and finalize.
all right, do we need a motion for this to go to ZBA?
That's your normal practice.
Right, all right. I'm gonna offer the motion that we send this applicant to the ZBA for their interpretation on all things that the applicant will deem necessary for them to move forward. That's my motion. Do I have a second?
Second.
Could we have some discussion?
I'm gonna
I
have a
would
discussion,
suggest,
yep.
I understand that, but you might want to just refer them over to the ZBA for all necessary variances. You can include that in the
I
motion.
didn't say that?
Okay, if it's all necessary variances, then I missed them. All right, because it's incumbent on them to seek all the variances that are necessary for the
need, right, that
plan
they need,
under the current
right.
code. We know that there's a lot area variance, haven't looked at it for other changes or other things that might have impact.
Well,
So,
my motion
okay.
is to leave it on to the applicant to do their due diligence to get any and all variances that they need. And usually, as customary, we send our letter from you to them as well.
Mm-hmm.
Anyone else with a discussion here on the board? All right, with that being.
Maria?
Yes, sir.
The only thing that I think
Sure.
you need to consider, and again, I don't think we're resolved yet, this whole revocation thing and whether or not that's going to be put before a full complement of the board. But if you're going to be referring it to the ZBA, given past comments of the board, I would assume that you would want a time limit on the applicant proceeding diligently with that application before the ZBA, so that you don't simply refer it to the ZBA and then they come back in 3 years.
Well, I was gonna do a second motion for an
Okay.
extension.
That's fine then.
Is that okay?
Yes.
Depending on how
does.
the board votes right now. Any other thoughts or concerns from the board members? No. All in favor?
Aye.
Aye. All
No.
against? Okay, with that being said, I'm gonna offer a motion. When you say March, our second meeting in March,
I would think so, yes.
which would be, because to get the application in, you can't get on I'm trying to figure out the dates here, because you're not gonna get on the December's
Right.
agenda, because that's already set. And depending on when you get everything into the ZBA, you'd have to get it in 2 weeks before their meeting,
Right.
which would be in January, if they can get you on the, so I'm not sure,
Well, then
March is
April.
like 4.5 months, I'm thinking 6 months extension.
Well,
Well,
6 months is fine
yeah.
too. You know, that they would have that much time to do whatever they need to do and get a decision and come back before you.
And if for some reason the
They meet once a
ZBA
month.
They meet once a month. and
Right,
for whatever-
sometimes they don't have a quorum, and
Yeah.
sometimes,
No,
so.
they've been pretty good with their quorums.
No, but we plan to submit as soon, we
Yeah.
will do everything we can to get on the January agenda.
All right, and if the board approves a 6-month extension, if for whatever reason you're delayed at the ZBA level, you know you have to come back and ask for the extension,
That's
because
fine.
we're not gonna reach out to you.
That would be June 6th.
June 6th is our 6 months. And I think that's going to the ZBA and going what they need to do. I think that's gonna be fair enough on my part.
And what we're gonna have to do is, assuming we get either, listen, whatever result we get from the ZBA, we're gonna have to prepare to come back here too, so that's gonna take a little while.
Right, that's gonna take-
Right,
okay.
so whatever they just depend on, so.
All right, then
I think that's fair.
All right, I'll offer a motion that we grant an extension to June 6th. Do I have a second?
I'll second.
Any discussion? All in favor?
Aye.
Any negatives?
No.
You said yes to
I
that?
said yes to your no. Yes to your negative.
All right, so there's
No, no,
three
or
yes,
yes to your negative.
there's 3 yes, 1 no. Okay,
Correct.
that's what all right. All right, so Dennis will draft a letter to the ZBA, letting them know that you're coming, so everything is on your shoulders to do your due diligence within the next 6 months. Okay?
Great,
All right, anything else
Thank
from
you.
you?
we're good.
All right, thank
Happy
you.
holidays, everyone.
You too, have a good night. Anything else from anybody? Dennis, do we have a public hearing on the 20th rather? Today's the 6th. Dennis, did we schedule a public hearing for the 20th? Did we do something for the 20th?
I think so,
We did, didn't we?
I think so,
Okay.
yeah,
Was it mobility?
yes.
Okay. All right, then. All right. So at this point, we will have a second meeting in December, which will be December 20th, unless, if I'm mistaken, we don't have a public hearing, and then we'll see if all my board members will be together, because I know that's the last night of Hanukkah, right? Yes. All right, with all that being said, I'll make a motion to adjourn. Do I have a second?
I second it.
All in favor?
Aye.
Aye. Everyone have a good night, and thank you for coming out.